Namaste, Suswagatam, and welcome to our Saturday edition of Legal Words of Wisdom, Nyay Gyan Ganga. As you know, we have weekly two programs, one on Saturday at 8 p.m. and our regular program on Sunday at 8 p.m. And today is the episode 18 of our Legal Words of Wisdom series. And as usual, we have with us Dr. Subramanian Swamy, the founder, president of Virat Hindustan Sangam, and our guest speaker, Dr. Venkat Iyer, who is based in UK. And as you all know, he's a barrister, he's a mediator, and and a legal academician. And he has been practicing earlier at the Indian bar and then subsequently shifted to UK. And he has been very kind enough to conduct this series of programs to educate the common man on the importance of law and the knowledge of the law. So, with these opening remarks, we welcome you all across the globe to our 18th episode. And today we will be discussing an extension of last time's discussion, which was on copyright. Today we'll be discussing intellectual property, further challenges, intellectual properties and further challenges. Although intellectual property has brought huge benefits to the world, it remains a controversial issue. Last week we saw how the concept of copyright operates. What about other types of intellectual property? In particular, how do trademarks and patents work? Can they protect products of traditional knowledge like basmati, rice, turmeric, neem, and yoga? What can be done to prevent disputes arising in these sensitive areas? These are some of the issues that will be discussed in today's episode. I have with me my co-host, Mr. Ramesh Swamy, and I also have to thank our technical team led by Ashish Shetty, Vishal Mehta from Mumbai, Ishwar Iyer from Navi Mumbai, Tejas from Pune. Then we have Rakesh Gadgi from Karnataka and Swaminathan from Chennai for their background support in putting the program, the technical and the commercial aspects together to beam this program to you every Saturday at 8 p.m. I would like to remind our viewers that we will, as usual, have our Sunday program, which is the regular Gyan Ganga, tomorrow at 8 p.m. And we will be having an important and interesting discussion on the present budget at tomorrow at 8 p.m. in our regular program. Very soon, we will, after the legal Gyan Ganga gets over sometime in the month of March, that is next month, we will be starting our economic words of wisdom, Arthik Gyan Ganga series for the benefit of our viewers. So with this, it is over to Dr. Swamy for his introductory remarks, and then it will be Dr. Venkat Iyer, today's topic being intellectual property, further challenges. Over to Dr. Swamy.
Thank you very much. I just basically would like to give a backdrop to today's discussion in the context of what we have covered so far. Now, intellectual property rights, essentially, I mean, I know it very well because when I was Commerce Minister, I had to go to Brussels for a gigantic conference of about 118 nations to create a new WTO and a new GATT, General Agreement on Tariffs and Trades. And for the first time, we introduced as part of the trade law, intellectual property rights. And through that, we got a great deal of access to every country's internal economic system also. So why is it so important to make this issue of intellectual property rights? The word intellectual is used because it's basically a product of your brain, which is converted into something usable. So the intellectual property rights is to encourage new creations that are made by human beings. They make an effort, sometimes they succeed, sometimes they fail, sometimes they fail and then succeed. And therefore, a lot of effort, time, your part of your life is invested in something that will improve the conditions of living of the people and the way we do it. So, intellectual property rights is to encourage these people to see that all their efforts is not copied by somebody else and misused by somebody else. But I would like to add that I expect that Venkat will tell us whether intellectual property rights are for life, or there is a time period after which there's no intellectual property right. You can copy, you can take over, you don't have to pay any any fees, nothing. Saying that, as an economist, say that for a long time, till maybe mid 50s of the last century, 1950s, it was thought in economics that development, progress, increase in national income output takes place because of more capital and more labor. And then we ran into a problem in economics that the more capital and more labor you use, the more will be the law of diminishing returns operating. As you put more and more in of capital, you will get less and less increases in output, and same thing with labor. So then came the idea that, well, that is when you start moving along the curve. If you have the base as the labor and the vertical axis as the capital, the curve goes up and starts tapering off. But if you go from one curve to another curve, then there is unlimited possibilities of growth. And that means that how do we go from one scale to another? That is by raising productivity of both capital and labor. How is that done? By new innovations. And these new innovations or new ways of doing things, that is the intellectual property that you get from scientific research. So therefore, this has to be protected, and how is to be protected is to be seen. First, and then last point I want to make is there are 4 categories, and each of them are for different reasons. First category is a patent. Patent is to prevent what you invented to be stolen and used by somebody else without paying your fees. So that patent, you have to register for it, you have to prove it, and there is a World Patent Organization, intellectual property organization is called now WIPO in Paris, and the WTO has a court where you can go and prosecute people for stealing your intellectual property. So patents is a separate category. You have invented something, and you are now being told that yes, because of your unique research, you have produced this, and that nobody can copy it or use it without your permission. And if they take your permission, of course, they'll have to pay some fees for it. So this is a patent. Second is trademark, which is a distinguishing mark exclusively for you. And the moment you see that trademark, you know who's the manufacturer of it. If I see a McDonald's restaurant, I know that big whatever that big sign where it's like a rainbow or a gateway. And so like that, every recognized commercial institution has a trademark, and that trademark cannot be used by anybody else, and there are lots of litigation on that. Then you come to or you see even Facebook also has a trademark. You can see it. Copyright is the third. It does not protect ideas, copyright, but the original works such as art, music, software codes, these are products of your brain, and they have a copyright. That is, you can't use it without permission. What's the difference between a patent and this? Patent is for a new invention. This one is a a composition that is created. Music is not something new, but different ragas, and how you combine them into a song, all these things it make it, it creates this new product, and that is, therefore, you have a copyright to that. And finally, something called trade secret. Trade secret is formulas. You have a formula, chemical formula, you want to keep it secret. You have a corporate strategy, that's also considered as part of the trade strategy. Confidential information about a variety of things. So these are things. So these four categories constitute together what we call as intellectual property rights. Over to you, Venkat. Uh, we are all eager to waiting here to hear you now.
Thank you. So last week we discussed copyright, which is, of course, the most commonly encountered type of intellectual property in many societies. It became apparent during the discussion which followed that there was some interest on the part of our audience in other types of intellectual property, notably the more difficult ones, such as trademarks and patents, as well as, of course, in the concept of traditional knowledge, geographical indications, etc., whose status, as it happens, is more ambiguous. I'm therefore planning to address those aspects of IP today. But before I do so, I need to make a few important preliminary remarks. The first thing I wish to say is that this area of the law is not as clear cut as, say, copyright, which we discussed last week. Not only are some of the concepts involved quite nebulous and difficult to accommodate within the better understood principles of law, but they're also susceptible of multiple and sometimes clashing interpretations for the purposes of legal classification. Even lawyers find them difficult to understand, so I'll have to simplify what I'm saying to a very large extent. To make matters worse, how you treat things like traditional knowledge will depend to a much larger extent than is usual on your ideological orientation. This makes some of the discussion quite emotive in nature. So, if you have a strong belief in capitalism, in the sanctity of property rights, in the importance of contract law, in the usefulness of what may broadly be called the Western system or framework of the law, then you are likely to adopt a position which is going to be very different from the position adopted by a socialist who hates free enterprise and who believes that a system of law which countries like India follow is a colonial construct that is designed to oppress. That is a gap which is not easy to bridge. All I would say, as I've repeatedly pointed out in my previous talks, is that even a robust commitment to capitalism and the free market should be tempered with ethical values and also self restraint, which means, in simple terms, that those with huge bargaining power need to exercise that power with responsibility. It requires what my old guru Nani Palkiwala used to call obedience to the unenforceable. But I maintain that the free market has much to offer, which it would be foolish to reject out of hand. Another point which I need to stress quite strongly while dealing with this topic is also a point that I've made many times before, namely that where the law tries to regulate sensitive and difficult areas of human activity, it needs to strike a careful balance between the rights and interests of the various stakeholders involved. Now, whether that balance has been struck correctly will often be the subject of intense debate because an assessment of it is to some extent subjective and also dependent on such factors in the case of this particular topic as how nationalist you are. Why do I say all this? Because I suspect that many viewers and listeners may disagree with what I'm going to say. But I'm not going to hold back my views simply to quote, popularity. In matters involving opinions, there's always room for disagreement, and I hope that you will take my remarks in that spirit. I also need to make one other fundamental point, namely that the law in these areas is not only extremely complex but also remarkably vague, which means that anyone who claims to be able to give a definitive answer to many of the questions posed will either be a very brave or a very foolish person. All that one can reasonably try to do, I think, is to offer informed guesses, which may or may not turn out to be true. So, let's get straight into the subject. Perhaps a good starting point would be to deal with the question that Jagdish had posed on behalf of a viewer, a certain Mr. Shetty, last week. Namely, why are people prevented from using certain words or phrases on intellectual property grounds? His query related specifically to the terms Siddha Yoga and Swami Muktananda. From whatever further information I've been able to obtain about this query, and Mr. Shetty has since written to me directly, it seems that he's writing a book about a certain dead Swami who belonged to the lineage of Muktananda, and he wants to refer to Muktananda in his book. I cannot see why that should be legally problematic, because those two terms have been trademarked in relation to particular commercial activities by a certain foundation in the US, not in a blanket way. There are otherwise, um, uh, the situation is otherwise quite similar to a situation where common terms whose use is unlikely to hurt the commercial interests of the organization which owns the trademarks will always be allowed. However, there is another issue which Mr. Shetty needs to be careful about, and that is if he intends to use any images or words which enjoy copyright and which would therefore be legally protected, then he would do well to seek the permission of the holder of copyright. There are, of course, exceptions that copyright law makes for fair use, etc., which are relevant in this context. In general terms, therefore, when it comes to trademarks, the law allows any word or phrase or symbol or sound or design, or even a combination of them, which identifies and distinguishes goods or services of one party from those of others, to be registered and used exclusively. But there are certain conditions attached to what can and cannot be registered as a trademark. First of all, a trademark cannot be offensive, so it cannot contain swear words or pornographic images. Secondly, it cannot be too generic. For example, water or plastic or rice or anything like that. Thirdly, it should not mislead people. For example, it should not contain the word refined for goods that are not refined. Also, it should not be too similar to certain state symbols like flags or hallmarks. If you want to get a trademark, you'll have to bring your application under certain specified classes of goods and services. When I last checked, there were, I think, 45 classes under Indian law. There are also ways in which the grant or the proposed grant of a trademark can be challenged. For example, where it causes confusion or deception in the course of commerce, or where it contains any matter which is likely to hurt the religious sentiments of any section of the population. Incidentally, the relevant law in India is the Trademarks Act of 1999, read with rules which were made under the Act in 2017. But it is worth noting that there is another concept called passing off, which is also relevant in some cases, and this is covered by common law. Under passing off, the goodwill of providers of goods or services is protected by offering a remedy against false representations which may deceive customers into believing that the goods or services which someone is providing are really those of someone else, usually a more reputed or well established business. But passing off has certain limits, including that the goods or services in question must be very similar. There was an interesting case in Malaysia a few years ago, which shows how these principles operate in practice. A local restaurant which served typical Malayan and Indian food called itself McCurry, and McDonald's, which has a presence in Malaysia, decided to sue it on the grounds that its customers may think McCurry's is part of the McDonald's chain. The smaller restaurant pointed out that its logo, lettering, color scheme, etc., were different from those of McDonald's. Also, crucially, that it did not serve food items that McDonald's was famous for, namely burgers or French fries or milkshakes, etc. And yet, in the first instance, the McDonald's Corporation succeeded in the High Court. But when the case was taken in appeal to two higher courts, it became clear that passing off would not apply because, according to the courts, simply by adding MC, Mec, to its name, the smaller restaurant had not passed itself off as having any connection with McDonald's. The courts ruled that McDonald's did not have the monopoly over the MC prefix. There were similar cases elsewhere as well, which also failed. For example, many restaurants call themselves McChina or McIndia. But if you had a situation where the rival businesses were selling very similar products, then the result would be quite different. I remember a situation in India many years ago where a shop selling footwear called itself Bala, Bala, and used a font and a get-up which was very similar to the logo of Bata, the Switzerland-based well-known footwear company. The only difference being that the smaller shop substituted the letter L for T. That would, of course, be an open and shut case of passing off. But I don't think Bata thought it worthwhile to sue the smaller entity, especially in a country where enforcing your rights is such a nightmare. Now, returning to our original discussion, I want to take up the other issue which was referred to last week, namely, where do products like neem, turmeric, etc., stand in relation to the law on intellectual property? To this, I want to add pharmaceuticals, which have also been the subject of intense and a frequently heated debate in recent years. This will involve a look at yet another form of intellectual property, namely patents. Let me give you a brief explanation of patents before looking at the more complex questions. In simple terms, a patent is a form of protection given to an invention, and the invention in turn must relate to a product or a process that is new, which involves an inventive step and is capable of industrial application. There are certain inventions for which patents are not given. For example, an invention which is obvious or frivolous or contrary to well-established natural laws, or an invention which is contrary to law or morality or injurious to public health. Also, for policy reasons, patents are not given to a mere discovery of a scientific principle or the formulation of an abstract theory. Slightly more confusingly, patents are also denied to a mere discovery of any new property or new use for a known substance or process or even machinery, or simply an arrangement or rearrangement of known devices. This is, of course, not a comprehensive list, just an indicative one. Focusing specifically on pharmaceuticals, which for the sake of convenience I shall call drugs, India had a long battle with foreign drug companies who have sought to market their products in India. We need to remember that it costs billions of dollars to develop drugs that are safe and effective for use on humans. Out of several thousand potential drugs, only a small handful make it to the market, which means the investment involved is massive and speculative. Not surprisingly, those investing the money look for returns in the form of profits on the sale of their products. And the only way those profits can be assured is through patent protection, so that you don't have a situation where those who have not spent any money on research and development compete unfairly with those who have. During the 1970s, India had a patent law which was very weak from the point of view of innovators. It only protected products, not processes. This allowed Indian drug manufacturers to engage in what is called reverse engineering, that is, using slightly different processes and undercutting foreign companies which had spent a fortune developing drugs. The situation was most unsatisfactory, but it was justified by the prevailing socialist ethos of the time. But when India aspired to join the WTO, something that Swamy just referred to, it had to change its ways. The Indian Parliament was therefore dragged, I would say kicking and screaming, to come up with a new law which not only allowed for product patents but also increased the term of patents from 14 to 20 years to bring it in line with international practice. I actually wanted to correct Swamy last week about this, but the discussion had moved on before I could interject. But there are some catches. First, the product patents will only be recognized for patents issued in India. The 20-year period will start from the time of filing of the application, not from the date of the grant of the patent. And like court cases, there is a massive backlog of applications to be contended with. But the implementation of the patent will only take effect from the date of the grant, which means that any generic drugs already in the market can continue to be sold until that date, um, uh, in spite of falling foul of the new law. Also, fresh patents will not be granted for new indications for an existing drug, and so on and so forth. There's also a highly controversial and ominous provision which allows for compulsory licensing. I know that a tougher patent regime is seen as harsh on the consumer and is very unpopular in countries like India. But that is a price to be paid for innovation. And don't forget that the regime applies equally to any company, whether foreign or Indian. So there's nothing to stop Indian companies from taking advantage of the system. Many people are surprised, and I would say saddened, by the defeatist attitude undertaken by those opposing stricter IP rules. It seems to suggest that Indian entrepreneurs are admitting that they cannot ever compete with the outside world, which is odd given that there is so much talent in India. And as Swamy has frequently said in his lectures, the key to becoming a developed and successful country is, at the end of the day, innovation. There is another side to this story which cannot be lost sight of. It has to do with serious concerns expressed over the extent to which substandard or spurious drugs are manufactured and sold in India. It is reported that just 1/4 of the 12,000 drug manufacturing units in India have been found to comply with the WHO's good manufacturing practices, and that up to 20 to 25% of all drugs sold in the Indian market are counterfeit. The ultimate victims of such lax attitudes to quality control are ordinary, I would say, especially poor Indians. There is no point in blaming multinationals if the country cannot get its own house in order. Many of you must have read about the Ranbaxy scandal, which led to that company admitting in a US court, I think it was in 2013, to selling adulterated drugs. Think of the shame that that incident brought to India as a whole. I don't have the time to say more, but I would ask you to read an illuminating book called Bottle of Lies, published a couple of years ago. Moving now to Neem, etc., that topic falls under what is called traditional knowledge, which is an emerging area of the law. Strictly speaking, it is not intellectual property as that concept is understood, but it has resulted from a demand for protection from indigenous peoples, local communities, and certain governments in the past, I would say, 20 odd years. Broadly speaking, there are two subsets designated by the terms genetic uh, resources and traditional medicinal knowledge. Also covered in this is folklore. Since our time is limited, I will look at this issue with a couple of tangible examples. Let's take basmati rice first, which created huge ripples when a US-based company, which is called Rice Tech, RICETC, was given a patent by the US Patents Office in 1997 for a hybrid of basmati with American long grain rice, which this company started marketing if I remember rightly, as Texmati and later Kasmati. There were huge protests from NGOs who challenged the grant of this patent, and the Indian government, of course, joined in. Rice Tech argued that its actions were legitimate research and development, which resulted in creating a rice variety comparable to basmati, and crucially, that the patent did not prevent Indian basmati farmers from exporting their rice to the United States. The US Patent Office then began a detailed investigation, at the end of which it rejected many of Rice Tech's claims but upheld three relating to hybrid varieties which were developed by the company. In effect, the patent owner argument was resolved, and the patent over basmati was narrowed quite significantly. Both sides in the battle claimed victory, although the Indian government and the activists were still unhappy because basmati was not given given what they expected, namely a form of general protection. Another attempt was made, this time through the US FTC, asking what the name basmati should enjoy in law. In other words, that this name should not be used for rice grown in the US because it was traditionally only grown in India and Pakistan. Interestingly, no formal application was made to treat basmati as a geographical indication, GI. That effort failed, with the FTC holding that no great injury would be caused to consumers, that basmati was simply being marketed as aromatic rice, not rice grown in any particular region, and that the company was selling it clearly marked as American basmati rice, so that no one was misled. Now, GIs have emerged as one of the most important instruments of protecting quality, reputation, and other characteristics of goods, essentially attributable to their geographical origin. And they came out of the TRIPS process, in which I think Swamy was involved. India has passed a law called Geographical Indications of Goods Registration and Protection Act in 1999. This act seeks to provide for registration and better protection to goods by keeping out unauthorized entities from misusing GIs. Interestingly, when India tried to protect basmati rice in the EU as an exclusively Indian product using a GI law, Pakistan objected and announced its intention to challenge that move. It'll be interesting to see how that battle plays out. One of the morals of this story is that when it comes to protectionism, the fights are not only between developed and developing countries, but also between developing countries. There is one other uncomfortable lesson worth noting in all this. It is that, however right India may be in protesting against the actions of Western countries and companies, it would do well to recognize its own failures and shortcomings. Among these are not paying enough attention to formulating laws in a timely manner, not making sure that those laws are smart enough to deal with emerging global developments and trends, not having a clear vision and long-term strategies for dealing with foreign entities. I would say also not cleaning up its legal system to make it fit for purpose, and of course, not rooting out the corruption which is so endemic. Now, why are products of traditional knowledge not susceptible of getting protection as, say, patents? Partly because patents are usually granted to identifiable inventors, not to communities at large. Also because the evidentiary threshold for patents is quite strict, even though that threshold was reached in a few cases like that of neem and turmeric. It is particularly difficult for someone to show proof of a distinct moment when a new and previously unknown result had emerged in the form of an invention. Documentation is also usually lacking when it comes to traditional knowledge. This calls for the creation, I would say, in developing countries, of easily searchable databases where hard information about traditional knowledge is prepared and stored. Let's look at another example of traditional knowledge which has come up during our discussion last week. It has to do with turmeric or haldi. Here, the story is briefer and, from India's point of view, happier. But it's also a story which shows how India has frequently been caught napping and then waking up suddenly to complain. Apparently, the first time turmeric became an issue was when two researchers at the University of Mississippi Medical Center applied for and obtained a patent after proving that the application of turmeric on a wound healed that wound, something that Indian grandmothers have known and practiced for generations. There was no opposition to the patent application until after it was granted. Then the CSIR in India sought its revocation on the grounds of existing what is called prior art, that is, evidence that the invention was already known and in existence. And they did that by showing references to turmeric's healing properties in certain ancient texts. Incidentally, in this case, the researchers involved in the US were not some evil foreigners, but people of Indian origin. Yet another example of what is called biopiracy from India, and which made headlines a few years ago, concerned neem, a shrub or a tree which has a range of extremely useful chemicals, allowing it to be used in pesticides, fungicides, laxative, toothpaste, etc. Incidentally, neem is not unique to India. It exists in some 50 countries worldwide. In the 1970s, an American company called Grace obtained a patent on the use of neem oil as a fungicide. And when that company began buying up neem seeds in huge quantities, alarm bells began to ring in India. A group of activists, supported by international campaigning organizations, filed complaints demanding the revocation of the patent. They showed ancient Indian texts, which, as in the case of turmeric, demonstrated that the healing properties of neem had already been well known for decades previously, and that the company had not made any novel invention. Subsequently, the patents were revoked. I referred a minute or two ago to the term biopiracy, which is how activists describe cases like those of turmeric, neem, basmati rice, etc. Now, that is not only a loaded term, but also one which is not easy to legislate on, mainly because it is difficult to define legally. But a more fundamental problem is that when it comes to traditional knowledge and indigenous rights, these concepts do not lend themselves easily to modern understandings of intellectual property. To put it simply, while the developed countries and their institutions consider the taking of biological material, which is commonly available in various parts of the world, and looking at them closely is legitimate R&D activity, developing countries and activist groups treat such activity as biopiracy. There is, in other words, a gap between notions of traditional knowledge and the modern IP protection system. Now, there's no doubt that businesses, whether outside or within India, are greedy for profits, and some of that greed cannot be justified on ethical grounds. To that extent, all attempts at gaining commercial advantage unfairly deserve to be dealt with and dealt with robustly. So don't get me wrong. Unfortunately, a lot of the opposition to the activities of companies comes from ideological motivations. And that carries the risk of the system of free trade and sanctity of contracts, which has led to so much prosperity around the world, being damaged. Only a couple of years ago, scientists in Europe were expressing concern that introducing too much regulation might stifle research and also innovation. That was related to a demand from activists that digital sequence information concerning genetic data from organisms collected around the world and kept in publicly available databases for others to study, not actual biological samples, by the way, that such information should be brought within the purview of international conventions. Now, such concerns cannot be lost sight of. Clearly, there needs to be a balance struck between the legitimate interests of commerce and the aspirations of indigenous communities to protect their knowledge and resources. And let's not forget that IP piracy, if you want to call it that, is not a one-way street. Think of the number of Western books that have been illegally copied and sold on the streets of India, or the massive volumes of software illegally installed on people's computers up and down the country, the widespread illegal copying of storylines and music in Bollywood movies. And you'll get a picture that doesn't by any means show India in a favorable light. There's one other uncomfortable truth, and it has to do with India's own lax attitudes, not only to IP protection, but also to quality assurance. Some of you may have been witness to shocking reports from time to time of how Ayurvedic medicines prepared and sold in India have dangerous levels of toxic metals like lead, mercury, arsenic, cadmium, etc. When samples of these were tested in countries like the US, Canada, and Australia, they revealed abysmal levels of quality control. The point here is simply that India's claims and protests on the world stage could have been more credible if it had got its own house in order first. I think I'll stop there because I've come up to the end of my time, and we can hopefully have a discussion. Thank you.
Ramesh, your mic
No,
is off.
Dr. Swamy is muted on the other side.
I am.
Just unmute him. Yeah, I know it's okay, Dr. Swamy. Now you're okay.
No, I have a short question before my colleagues take over. I was in the negotiations as a commerce minister when the so-called Dunkel draft converted itself into the trade general agreement on trade and tariffs, the second version. The first one was passed in 1948, and this was in 1994. And the question that was hottest discussed is that we had a patent law which said the period of the patent will be 14 years. And let the readers know, I mean listeners know, that these patents and all are not forever. So if today somebody says, we should have calculus was because it was discovered by Bhaskaracharya first, and therefore we should have a patent. It's too late now. And any new invention can be imitated, duplicated, so on after 14 years as the law then prevailed. Now, the Western nations are adamant that it should be 20. And we ultimately made it 20. I mean, that is not when I was commerce minister, but after the next government came. And I think Pranab Mukherjee became the commerce minister. And Narasimha Rao's government came. Although I had a minister's rank position, but it was not as commerce minister, but more in terms of WTO's functioning. So I'm asking you, how can you decide whether it should be 14 years or 20 years or 15 years? You see, isn't this a bit arbitrary? And so there must be some scientific way by which you should draw a line, not a flat line in as in the patent law of 14 years.
Yeah, well, there's no doubt that to some extent these cutoff periods are arbitrary. Let's accept that as a reality. But in the case of patents, I remember the discussions that used to happen in those days. The argument used mainly was that 14 years is too short a period during which it is possible to recoup the profits, the investments that particularly the drug companies have had to put in for the discovery of new drugs. And at that time, I remember we're talking about about 20 or 20, 25 years ago. It used to cost just over $1 billion to come up with a new drug. And a calculation was made about how long it will take to recoup that investment. And it was agreed across the board that 20 years would be reasonable. Now, it is perfectly possible for an argument to be made that why 20? Why don't we have 15 or 18 or something in between? Possible. But 20 was seen as reasonable also because remember that under Indian law, the 20-year period doesn't start from the date of the grant of the patent. It goes back to the date of application. And between application and the grant, there can be a few years. So that those few years are lost to the patent owner.
Okay. Good point. Okay.
Yeah, Dr. Swamy, I think you made a statement in Cancun. I guess this is that there is a document out there which I put in the chat window. That the statement that you made in December 1990.
Yeah, Uruguay rounds at Brussels.
Brussels, yeah.
Yes.
Brussels. Okay. So now,
what was the statement?
I opposed the patent tooth and relaxation.
Carla Hills was representing US.
Yes.
Yeah.
Huh?
Carla Hills.
Carlyle.
Yeah. She was the US trade representative.
Yes, she was tough lady. You see, what happened, I must tell you, I mean, it's a little, not a very big digression, but a small digression. Generally speaking, I found when I went to this international conference, that traditionally we sided with the communist countries. All right. So anything the US proposed, we would oppose it. And in fact, I had to sack my commerce secretary, and bring in Montag Singh Alwalia in his place, because the commerce secretary I inherited was a communist. I'm a communist minded. So I thought that the best way to do in a conference is to have a deal. So this lady who was the negotiator for the United States, she heard that I'd come and my background of Harvard and all that. They must have been. So she wanted a meeting, and we were very keen to get a relaxation on export of garments to the United States. And the United States was very keen in getting access to agriculture in Europe. So I decided that we'll make a deal. And that deal was something that lady said to me, Carla Hills, that it's like a breath of fresh air. I never expected an Indian would talk to me in this language of a deal. And so it created a totally different atmosphere. It is at that stage that the other European nations began pushing for uh, increasing the patent period. And I knew that, already I was being, all these bureaucrats were campaigning against me. I got the garment quota ban removed by siding with the Americans that they can export their agricultural products to Europe without these high tariffs. These high tariffs had to be brought down. And for agreeing with the Americans on agriculture, I got the deal on garments and textiles. But there was such a furor in India that I had sold out to the Americans. But ultimately, my thing prevailed, and part of it was that it took a very hard line on patents, and so people got mollified. But I'm saying that, you see, the grip of the left wing in all this trade, international trade, has harmed us enormously.
Yep.
We have never been able to make deals with countries like the United States in saying that I'll give you an easy access here, market access, and you give me a market access. And in fact, we got market access to agriculture also, and basmati rice started going after that only into the United States. So this is the part of the game. But so that's why I asked you about this patent. I'm sorry to take your time, but
that's fine. Yeah, but also, in that context, it's worth noting that smaller countries in Asia, look at Singapore, or in the Middle East, Israel, they've had no problems. They are quite relaxed about agreeing to sensible proposals rather than have this mindless opposition to anything that is put by the West. And I think you identified an extremely important factor in all this. I'm sorry to say that the attitude has not gone away completely. Even today, when I see Indian bureaucrats at international fora, it is just the same old story of inflexible, mindless opposition to anything that is Western.
Right, absolutely. The mind has been captured by the Soviet Union. The Soviet Union has disappeared, but still, its capture is still quite alive. Yeah.
Venkat, I have a question which is on the screen by an advocate from Chandigarh.
Yes.
Whether it will come under this purview.
Right. It's about the auction of heritage items. Okay, this is actually not, this is partly covered by intellectual property, but it would be more a case of theft and to some extent even criminal law, but definitely law of conversion, law of theft, and matters like that. And actually, I think, now Swamy will correct me on this, I think India has passed some sort of a law to protect antiquities. Am I right?
Yes, we have.
In fact, what Advocate Ajay Jagga of Chandigarh is referring to, that there is a law passed in India, especially Chandigarh, in view of the planned city there, and there were a lot of furnitures and street furnitures and other things which have been clandestinely stolen and being auctioned abroad.
Yeah, but don't forget the collusion of Indians in all this.
I know.
Most of these fellows who allow these items to go out are Indians, because without their cooperation, it's impossible, because they make huge profits. So let's not be starry-eyed and think that everything is the fault of foreigners.
Yeah. Well, they even we have at least one foreigner who's domiciled in India. But Ajay Jagga asked this question, but he is an expert. I think maybe we can have him on a program and explain what this antique exports is. And there's one in Saxena, our Anurag Saxena, no, Jagdish?
Yes, he is in Singapore.
He has done marvelous work on this.
The Indian idols have been stolen. He fights for them to be restored back to the original places.
I think we should have both of them on a program in the future.
Yep.
Okay.
Your mic is off, Ramesh.
Okay. Now, this is another question. So I just, Venkat, you can just read it. It says, a revocation of patent rights on certain pharmaceutical things owing to the ongoing pandemic. I mean, how did they revoke a patent? I'm kind of confused with that.
No, not revoke. I think what the questioner is, I think what he or she has in mind is suspension of patent rights for a limited period of time to overcome the pandemic. I personally would not be in favor of it. I run the risk of being considered hard-hearted, but the reality is you should recognize how much money and effort and time has gone into creating these drugs at very short notice. Incidentally, something of very topical interest is what appeared in the news this morning about Israel discovering not a vaccine, but a drug to combat COVID. And although it's very early to pronounce on the complete efficacy of it, out of the 30 patients who were given this drug, 29 fully recovered after suffering from severe effects of COVID. Now, that is a remarkable thing. And again, it points to the importance of innovation and, more importantly, the enabling environment for innovation, which only countries like Israel have. And so I would be totally against the idea of suspending patent rights simply because it is fashionable to do so.
Yeah, quite right. There has to be a reward for having staked all your time and your money and the risk, and it has to be compensated. How much time it requires for you to be compensated is you can have an argument, but there has to be a patent law.
And I suppose the answer to the possible objection, namely that, oh, these medicines are going to be so expensive and can a poor country afford it? The answer to that must be partly to do with government stepping in temporarily to subsidize the cost of these drugs. Again, one has to be very careful. You can't write a blank check. But also, what about civil society organizations, charities who have a big role to play, which is what happens in sensible countries. Charities come in, particularly the richer ones, and they take on the responsibility. Churches, other religious institutions. We can't rely only on the government. So the answer is not to suspend patents, but to find other ways of helping poor people.
Right. Well, we have made it to 9 o'clock.
Okay.
Okay, Jagdish, we can close.
Yeah. So, friends, it was another interesting session with Dr. Swamy and Dr. Venkat Iyer on the intellectual property rights. And as usual, Dr. Venkat Iyer and Dr. Swamy gave us a lot of insight into many of these issues, terminology, and past history and precedents. So we come to an end of another interesting episode on Nyay Gyan Ganga, Legal Words of Wisdom, on our Saturday show at 8 p.m. So we thank our viewers for their support and patronage. I also wish to thank my co-host Ramesh Swamy, and I also want to thank the technical team led by Ashish Shetty, Vishal Mehta, Ishwar Iyer, Tejas, Rakesh Gadgi, and Swaminathan for their background support. We'll be back tomorrow at 8 p.m. on our regular Words of Wisdom Gyan Ganga. Tomorrow, Dr. Swamy will be discussing on the budget, and we would request viewers to be tuned in for an interesting, informative talk on the budget. I wish to tell our viewers that very soon, probably somewhere around the next month in March, after the legal words of wisdom, Nyay Gyan Ganga is over, we'll be starting the economic words of wisdom for the benefit of our VHS viewers. So this is again on behalf of Virat Hindustan Sangam, thanking all our viewers across the globe for their patronage. Thank you. Jai Hind and Dhanyavad.
Thank you.